Okay, na? More volume alone. Okay. I think we discussed cooperative and the competitive one. You don't have too many prelims points. Confront. Okay, I bet I'll just sum up once. Competitive federalism. Simple terms. Again, let's not make it a main topic. Healthy competition between center and states and between the state. That's it. Very simple aspect. Healthy competition between center and states and between the states. Of course, so many are there. Various indexes, everything. They'll not ask a very less chance that they can ask about a question directly about competitive federalism. Good governance index. So what are examples for competitive federalism? Various indices, like as I told, so many are there. Good governance index, SDG index, etc. That is what you mean by healthy competition between center and states. Criticism, everything part is there, but that's all not part of your prelims topic. We don't have to discuss that. This is competitive. Then comes your confrontational. So in simple terms, confrontational means difference in opinion, ideology between center and states and between the states. Very simple definition, confrontational federalism. Obviously, this is a very negative impact. So many examples are there, we all know, like Kerala opposing CAA, Karnataka opposing new education policy, Tamil Nadu opposing NEET, Karnataka opposing NEP, three language, the Hindi angle, so many angles are there. Those are all confrontational federalism. Between the states, you have interstate border disputes, interstate border disputes. They can ask a question on all those things. But if they try to touch the prelims point, for example, because NEET issue was there, NEP issue was there, all those things, just from that prelims point only I am telling, because the examples is all not necessary here in this context. For example, let's say, take for instance CAA, fine. So Kerala government had said that what, or Kerala Assembly had passed a resolution saying that what, that they are against CAA. Now look at the legal point of view. So legal point of view is what? First point, according to Constitution, Parliament laws binding on the states means whatever laws that is passed by the Parliament, who has to mandatorily implement it? It is binding on the states. In other words, whatever Kerala says is what? No impact at all. Kerala has no option, or Kerala has to mandatorily implement it. Any state for that matter. It is just an expression of resolution, whatever they did. Kerala has to mandatorily implement it. Kerala has to mandatorily implement it because according to the Constitution, whatever acts passed by the Parliament is what? Binding on the states. That is first legal angle, Kerala CAA issue. Fine. Now second legal angle, which normally NEP issue, NEP 2020 issue. Again, Kasturi Rangan committee, all those things is a different point. Legal angle. Education is which subject? Concurrent list. Because of which amendment? 42nd Amendment 1976. In other words, till then education was what? State subject. Now it is a concurrent subject. Now what is the legal angle? That means both center and state can make laws or policies because it's a concurrent subject. Fine. Now the point is what? States have an option. States have an option to not implement, that is to reject such policies. See, for Kerala, whatever they did, they don't have an option. It is binding. Look at the point here. Here they have an option not to implement, or reject such policies because it's a policy. What if it is passed as an act? Just now I applied the point. If it is passed as an act, you have no option. What do you have to do? Mandatorily implement it. Because it's a policy, you have an option, you can say I am not implemented. In other words, whatever Karnataka and Tamil Nadu's decision that we are against NEP is legally valid. You can say that. Correct, that is the point. Now, another legal issue with respect to NEET exam. You might have seen because of some NEET, some Supreme Court case was going on and some NEET PG issue was there, all those things. First point is what? Again, all related to education. This is not through an act. Supreme Court introduced it. NEET is introduced by Supreme Court. Understood? Based on this, Government of India gave guidelines or the procedure, whatever you call it as. Now, because it is based on Supreme Court, what is the point? Binding on the states. Because it is based on Supreme Court's order. Whatever order given by Supreme Court is binding on everybody. So you have no option. You have to mandatorily implement NEET. Clear? Again, there is a legal angle. You are also again dealing with which subject? Education. Again means which? Because education is a concurrent list. Understood? Now what is the exception for states? States, one second. Because education is a concurrent list, states can pass their own acts, their own laws. But what is the procedure? You should get the president assent. This is kind of current affairs, this is kind of legal, everything. That's an exceptional point, extraordinary point you can say. And in fact, that is not there for simple reason. Yeah, so the simple reason, what Kerala, if you might have seen, Tamil Nadu has already passed such an act, but what it has not, it has still not received president's assent. So if you get a president's assent, you get an exception. That's the point. That is NEET issue. Then, okay, NEP, everything is fine. CBI issue was there, but you might have seen few states keep telling that we will not allow CBI to operate in our states because there is an option which says that the states can take back the general consent given to the states. In other words, when they take back the general consent, for every case you have to go and get the state government's permission, or else you cannot, CBI cannot look into that case. Fine, that's another legal point. Whatever, that's another issue. So that is confrontational federalism. Then you have fiscal federalism. I think broadly I've already told vertical devolution, horizontal devolution. Planning commission was there, that also is fine. Statutory grant, discretionary grant, anyhow we'll discuss it later. Bargaining federalism, okay, that's not important. Okay, fine. So from the prelims perspective, whatever is necessary from federalism chapter, mostly it is done. Now, come back to the, again, few what do you call as this factual part, salient features. First, let's deal with parts of the Constitution. Remember this year 2024 prelims they have asked. First basic point, what you have to understand. Originally 22 parts. Then 7th Constitutional Amendment 1956 deleted which one? Part 7, Part 9. First basic factual point. Then 42nd Amendment 1976, two new parts. Part 4A, which obviously is what? Part 14A is, which one is it? Tribunals. Then 73rd Amendment 1992, Part 9, Panchayats. 74th Amendment 1992, 9A, Municipalities. 97th Amendment 2011, Part 9B, which is what? Cooperative societies. This is the basic prelims point. I mean, the parts related facts. But of course, this year what they did, so they have asked about overall, I mean, not overall exactly, in part 18 they asked, I think part 20 they asked, and some another part also they had mentioned. That I'll tell you overall list. But this is first basics. Part 7, Part 9. So that means at present 25 parts. At present there are 25 parts, because that also they can ask a very easy question. Now just as a list if you want, please write. Again, you don't have to by hand this list because not necessary. Only because this year they asked that question. Even if you had seen in respective chapter also, you could have recalled. But just for your clarity, please write the list. Part 1, Union and Territories. Part 1, Union and its territories. Be a little quick because 25 parts you have to write. Part 1, Union and its territories. 2, you don't have to write part, just keep writing 2. You have to write in Romans. Part 1, Union and territories. Part 2 is what? Citizenship. 3 is very famous obviously. Fundamental rights. 4, DPSP. 4A. 4A is what? Fundamental duties. 5, Union government. 5 is union government. 6, obviously logically think what will be 6? States. 7 is deleted, that you will that are related to part B. 7 is deleted, you will have 8. 8 is what then? Again logically think union government, state government. Next is what is left out? Union territories. It's like that logically they have moved. Part 8 is union territories. Then 9, obviously just now we have mentioned panchayats. 9A, you know that 9A, 9B you write. 9A, 9B. Panchayats, municipalities, cooperative societies. Then 10, 5th schedule and 6th schedule. In other words, scheduled areas, tribal areas. Part 10, scheduled areas, tribal areas. Fine. Part 5 is union government. Part 6 is state government. Part 7 is deleted. Part 8 is union territories. 9, panchayat. 9A, municipality. 9B, cooperative societies. Then 10 is what? Scheduled areas, tribal areas. Then 11, center-state relations. Center-state relations. That's where you get your center-state relations, interstate relation. That is part 11. Part 12, finance and contracts. Finances, contracts and suits. Finance, contracts and suits. Means if you want to put any case against Government of India, all those things. Finance, contracts and suits, SUITS. That is part 12. Then part 13. Part 13 is what? Finance, contracts and suits. Tribunals. Tribunals is 14A. Interstate trade, correct. Trade, commerce and intercourse throughout the country, part 13. Interstate trade, commerce, or you can say overall trade, commerce and intercourse throughout the country. Article 301, 302, all those things. Fine. Trade, commerce and intercourse throughout the country, that is 13. 14, this public service commissions, UPSC, state PSCs. That is 14. Then 14A, you know, which is what? Tribunals. 14 is PSC, Public Service Commission. 14A, Tribunal. 15, elections. Election, that's what is 324, 325, 326. 15, elections. 16, special provisions for SC, ST, OBC, Anglo-Indians. Special provisions for SC, ST, Anglo-Indians. That's what is your reservations in Lok Sabha, reservation in Assembly, nomination of Anglo-Indians, women reservation, all those things is under 16. And so then 17, official language. Official language of union, official language of states, 17. 18, emergency, 352, 356, 360s. That's what is your this 2024 one. Very simple, but broadly. Emergency. Fine. Then 19, miscellaneous provisions. Means interpretation of the constitution, all those terms you have. Miscellaneous, extra. Then 20, amendment, constitution amendment. Amendment of the constitution. 21, temporary transitional provisions, 371, 370. 21, temporary transitional provisions. Temporary transitional provisions, that is 21. Then 22, which is what? Title, commencement of constitution. Title and commencement of constitution, 22. Title and commencement of constitution. Fine. Normally UPSC never used to touch it. Maybe maximum important points they used to ask, but this year, whatsoever reason, they asked about what? Or also you could have recalled, even if you had very basics also, if you had known, easily you could have recalled which part is what. But you never know, that depends. In the exam hall, you should be able to recall that. Now comes the schedules. Another very factual part, schedules. Because this year also they have asked a question on schedules, 8th schedule. Schedule, obviously, you know, first schedule is what? Names of states, names of UTs. Names of states, names of UTs. First schedule. Names of states, names of UT. Then second schedule. Second schedule is what? Emoluments, allowances and privileges of. Second schedule. Emoluments means salary, allowances, all those things. Emoluments, allowances, privileges of. Emoluments, allowances and privileges of. As a list you write A. President, Governor. President, Governor. B. Speaker, Deputy Speaker, Lok Sabha and Assembly. Speaker, Deputy Speaker, Lok Sabha, Assembly. C. Chairperson, Vice Chairperson, Rajya Sabha, Council. Chairperson, Vice Chairperson, Rajya Sabha, Council. Then Supreme Court, High Court judges. Then CAG. Supreme Court, High Court judges, and then CAG. So totally 9 people. I just combined it and wrote second schedule, that is Supreme Court and High Court judges and then CAG. Fine. Then third schedule, oaths or affirmations of, again very factual, but every year they are asking a question. Oaths or affirmations of A. Candidates contesting. Oath or affirmation of, as the list you write, A is candidates contesting elections to parliament or state legislature. Candidates contesting elections to parliament or state legislature. Candidates contesting elections to the parliament or state legislature. B. MP, MLA, MLC. Members of parliament and state legislature. MPs or MLAs or MLCs. All of their oaths. Then ministers. Ministers of Government of India, ministers of states. Ministers. Then Supreme Court, High Court judge, CAG. Ministers. After ministers, Supreme Court and High Court judges. Supreme Court and High Court judges. After that, CAG. CAG. Fine. This is your third schedule. Then fourth. Fourth is what? Allocation of Rajya Sabha seats to the states and UTs. Allocation of Rajya Sabha seats to the states and UTs. Allocation of the Rajya Sabha seats to the states and union territories. That's your fourth schedule. Then fifth, which I have already told, which is simple terms what? Special provisions for tribal areas. And which states, all of those things we have already mentioned. Special provisions for tribal areas. Fifth schedule. Sixth obviously, special provisions for tribal areas of Northeast. Special provisions for tribal areas of Northeast. Which states we have already written? Assam, Meghalaya, Tripura, Mizoram. And if you can recall the current affairs angle, recently which area is demanding that they should? 2 areas. One is Ladakh, second one is Arunachal Pradesh. If you have forgotten, please write. Recently, Ladakh and Arunachal Pradesh are demanding 6th schedule status. Recently, Ladakh and Arunachal Pradesh are demanding 6th schedule area, 6th schedule status. Fine. That's why if you have seen, Ministry of Home Affairs has appointed a committee, especially with respect to Ladakh, Sonam Wangchuk, all those things, they are conducting a protest, all those things you might have seen. Because the question mark is, there is no clarity in the constitution that can we give 6th schedule status to states other than the Northeast states. There is no clarity. Because as of now, in Indian history, it has only been for one. Northeast areas. Now Ladakh is not part of Northeast. Can you give that status to Northeast? Ladakh? We don't know. That's why they have appointed, Ministry of Home Affairs has appointed a committee. Clear? Again, other basic point, keep it in mind. Sir, on what basis will you include a state in 5th or 6th schedule? There is no clarity in the constitution. Understood? Means if you fulfill so and so criteria, you put them under 5th schedule. If you fulfill so and so criteria, you put them under 6th schedule. There is nothing like that in constitution. Ultimately, it is whose decision? It is a decision of Parliament of India. Very basic prelims point, please don't forget, right there. Constitution has no clarity. Constitution has no clarity with respect to criteria to determine a 5th schedule or 6th schedule area. There is no clarity in the constitution to determine 5th or 6th schedule area. No clarity in the constitution to determine 5th or 6th schedule area. Fine. Ultimately, whose decision? Parliament's decision. Keep that in mind. Then 7th schedule. It's very easy. Obviously, I don't have to tell. Union list, state list, concurrent list, all those things, keep it in mind. And then residuary angle, which is unallocated subjects. That is 7th schedule. Very simple. Union, concurrent, state, residuary. That you know. 8th. 8th was a recent question. 8th is what? It is not the official language. Languages recognized by constitution. You have to use the same word. Don't use it as official languages. Languages recognized by constitution. That's your 8th schedule. Languages recognized by constitution. Originally how many? Originally 14. At present 22. Originally 14. At present 22. Fine. Under that, what are those newly added 8 languages then? Newly added languages are A. Sindhi. Sindhi was added in 1967. Whatever, 1960s, Sindhi. Then 71st Amendment 1992. 71st Amendment 1992. What did they add? Manipuri, Nepali, Konkani. 71st Amendment 1992. Manipuri, Nepali, Konkani. Fine. Manipuri, Nepali, Konkani. 71st Amendment 1992. Then next one, 92nd Amendment 2003. 92nd Amendment 2003. 4 languages. Which are they? Bodo, Maithili, Dogri, Santali. 92nd Amendment 2003. Bodo, Maithili, Santali, Dogri. Bodo, Maithili, Santali, Dogri. Fine, this was the question, if you can recall, prelims question. Then 96th Amendment 2011. 96th Amendment 2011. Which is what? Odia renamed as Oriya. Sorry, Oriya renamed as Odia. Odisha. ORIYA renamed as ODIA. ORIYA renamed as ODIA. Odia. Fine. This is the 8th schedule languages basic facts. Again another basic fact clarify there. Sanskrit is mentioned. English is not mentioned. Look at it. So English is the official language of Government of India, but it's not mentioned in 8th schedule. Very simple fact. Sanskrit is mentioned, English is not mentioned. English is not mentioned. Again, what there is no what is there is no clarity about what? No criteria to add a language to 8th schedule. So on what basis are you adding Konkani? Why are you not adding Tulu? There is no clarity. No criteria to add a language to 8th schedule. So ultimately again whose decision? Parliament's decision. How do you add it? Constitutional Amendment 368. If you have that doubt also, that's why you have written the amendment names, right? Numbers only you have written. That means Constitutional Amendment. No criteria to add a language to 8th schedule. Who will add it? Final decision by Parliament. Article 368, special majority. Final decision, Parliament, 368, special majority. Final decision by the Parliament under Article 368, special majority. Fine. Who is demanding again? Tulu, Ladakhi, both are demanding. Demand by Tulu or demand to include Tulu and Ladakhi. Demand to include Tulu and Ladakhi. To include Tulu and Ladakhi. Fine. This is the 8th schedule, very basic aspects. Again, there is a current affairs angle. Recall. Just how many? I think last month itself they gave what? Classical language status extended to. Yeah, so write that because the UPSC has already asked, as far as my memory goes, twice or thrice they have already asked a question on classical language. This year again it's a kind of current affairs angle. Put adding classical languages. Classical languages. Point number 1, what? Not mentioned in Constitution. So it's not like your 8th schedule. Not mentioned in Constitution. Not mentioned in the Constitution. Point number 2, status given by Ministry of Art and Culture. Status given by Ministry of Art and Culture. Status given by Ministry of Art and Culture. Point number 3, what is the criteria? Criteria. Ancient history. At least you can say 1000 to 1500 years of history. Ancient history, in bracket you can say minimum 1000 years. Fine. Then old script and literature, again at least 1500 years old language, script, history, old script and literature, old script and literature. Fine. Then largely this is also there, spoken by large number of people, spoken by large number of people. Again there is no clarity, broadly this is the points, spoken by large number of people. Fine. On these aspects they will give you the status. We will give Ministry of Art and Culture will give. Now again what is the point which are given, right? First is what? Tamil, first language. Tamil was the first language to receive it. Second, Sanskrit. Tamil first to receive, Sanskrit second. Tamil first to receive, Sanskrit second, and then three languages together, which is Kannada, Telugu, Malayalam together. Tamil first, Sanskrit second, Kannada, Telugu, Malayalam together. Then they gave it to whom? Odia. So totally this was there. How many? 6. So Odia. Now they have given to how many? Marathi, Bengali, Pali, Assamese, correct. Prakrit also I think. Yeah, 5 total, correct? Yeah, 11. Yeah, please write that. Recently given to 5 languages. Marathi, Bengali, Assamese, Pali, Prakrit. So totally 11 languages. Marathi, Bengali, Assamese, Pali, Prakrit. Pali, Prakrit. Fine. Now what is the advantage? Simple advantage is what? Extra grants by Government of India for research on the language. Extra grants. This is a current affairs point. Extra grants by Government of India for research into the language. Extra funds by Government of India to research into the language. Fine, but they can ask about anything. Oh, 8th schedule they have asked. This one they have still not asked. It still means recently they have not touched. 16, 17, I think twice continuously they had asked this question. Current affairs angle. Now the other language aspect. Official languages. Official languages. Under that, according to constitution or according to original constitution, you write. According to original constitution, official language of Government of India is, according to original 1950 constitution, official language of Government of India is Hindi along with English. Official language of Government of India is Hindi, in addition English. English for only what? If for English you write in bracket 15 years, that is 1965. Hindi was there, continuous. English 15 years, that is 1965. Then what happened? Official Languages Act 1963, OLA. Official Languages Act 1963. English extended along with Hindi. Official Languages Act 1963. English extended along with Hindi. This time they have not mentioned number of years. English extended along with Hindi. Then of states, what about the states? Official language of states decided by state legislature. Official language of states decided by state legislature. Decided by state legislature. Fine. Normally they still not, they have not touched it, but 8th schedule they have asked, classical language they have asked. Easily if they extend it, they can easily ask this. That is official language of the states. Then comes the other one, which is language of the courts. Language of courts. Fine. For Supreme Court, only English. Supreme Court, only English. High Courts, only English. Supreme Court only English, High Courts only English. But for High Courts there is a check. However, governor can request the president, state governor can request president to include their regional languages. Governor can request the president to include their regional languages. Example, MP, Rajasthan, UP, Bihar have added Hindi also. Not like replacing English, addition to that. Uttar Pradesh, Bihar, Madhya Pradesh, Rajasthan have included Hindi. Now, under that, subordinate courts decided by state legislature. Subordinate courts decided by state legislature. Decided by the state legislature. Fine. Then don't get confused. When you say official language of Union, that is Government of India, it includes what? Official languages of the Parliament also. Whatever you have written official language of Government of India, it is same for what? Parliament also. So don't get confused. Both are same because Government of India means all legislature, executive combinedly we are talking. Okay, fine. So that is the language aspect. Now, last years they used to ask these questions. Newly added schedules. Every more or less, I think from the last 5-6 years, every year there is a question on schedule. This year they asked one question on schedule and one on parts also, 2. Newly added, very basic, obviously, 9th schedule. Which amendment? First Amendment 1951. 31 capital B. 9th schedule. First Amendment 1951. First Amendment 1951. Then which article? 31 capital B. Again, we'll discuss capital B 31B in detail there. But here I'll just write the core. Acts, those acts of Parliament and state legislature which are exempted from judicial review. That's it. Obviously, you'll be knowing. Those acts of Parliament or state legislature, or you can say and state legislature, which are exempted from judicial review. Those acts of Parliament or state legislature which are exempted from judicial review. Exempted from judicial review. Fine, then 10th is again a very easy one, which is what? Anti-defection law, 52nd Amendment 1985. 10th schedule, anti-defection law, 52nd Amendment 1985. 11th, very basic, quickly finish off. 11th, 73rd, panchayats. 12th, you know that also you write. 11th, panchayats, 73rd Amendment 1992. 12th, municipalities, 74th Amendment 1992. Fine. So from here you can easily expect at least one question every year. Schedule, parts combinedly. At 100% they have to ask. Fine. Constitutional knowledge. You can take it as factual knowledge also, but constitutional knowledge also. Then this one what we are going to write is very easy one. I mean very factual, very easy. Normally UPSC doesn't touch it, but it should be there. Borrowed provisions. From which country did we borrow what? Borrowed provisions. Then again a factual one, quickly finish off. 1935 Act. 1935 Act, obviously you know which one? Federal scheme. Federal scheme. Then PSC, Public Service Commissions, UPSC, State PSC. Federal scheme or federalism, you can also say. Public Service Commissions, emergency provisions, integrated judiciary, office of governor, integrated judiciary, emergency, office of governor. Then 7th schedule, then civil service, 7th schedule, civil service. Emergency, civil service, office of governor, what else? Public service commissions, integrated judiciary, all India services, all of them broadly. Then British, from Britain, also that's very famous, obviously we all know. Parliamentary system, rule of law, from Britain, very simple facts. Parliamentary system, rule of law, cabinet, writs, privileges, then what? Single citizenship, bicameralism, and then US, fundamental rights, Bill of Rights, US fundamental rights, judicial review, independent judiciary, and then removal of Supreme Court, High Court judges. Removal of Supreme Court, High Court judges. Impeachment of presidents. Vice President, office of Vice President. Impeachment of President, office of Vice President. Fine, that is US. Then Canada, Union of States, strong center, advisory jurisdiction of Supreme Court. Advisory jurisdiction of Supreme Court. Then appointment of governor by center. Appointment of governor by center. That is Canada. Then Ireland. Obviously, you know, DPSP, election of president. DPSP, election of president, nomination of Rajya Sabha MPs. Nomination of the Rajya Sabha MPs. And then South Africa, election of Rajya Sabha MPs, amendment of constitution. Election of Rajya Sabha MPs, amendment of constitution. Then Germany, Weimar Germany, what that is? Weimar means actually regime. Germany, suspension of fundamental rights during emergency, 358, 359. Suspension of FR during emergency. Suspension of fundamental rights during emergency. Fine. Then USSR, fundamental duties, justice. USSR, fundamental duties, justice. Then France is very easy, obviously, you know, republic, L plus E plus J, liberty, equality, justice. So liberty, equality, fraternity, liberty, equality, fraternity. Justice is USSR. Liberty, equality, fraternity. Liberty, equality, fraternity. Then Japan, procedure established by law. Japan, procedure established by law. procedure established by law. Then Australia, joint sitting, Article 108, joint sitting, concurrent list, trade and commerce, freedom of trade and commerce. Joint sitting, concurrent list, freedom of trade and commerce. Freedom of trade and commerce. Freedom of trade and commerce. Fine. So this is broadly the factual part. Every year, at least one question from parts, schedules, provisions. If sometimes two, but at least one is obvious. Then union and territories. Part 1, union and its territories. We should finish at least till preamble and then we can solve few questions. Union and its territories. Very simple ones obviously. The term called as Union of India means what? Only states. The term called as Territory of India. Very simple ones. States plus UT plus AT. States plus Union territories plus acquired territories. Fine. For acquired territories, clarify. At present, no acquired territories. States plus Union territories plus acquired territories. At present, no acquired territory. And no provision in Constitution for their administration. So there is no clarity in the Constitution. No provisions in the Constitution with respect to their administration. No provisions in Constitution with respect to their administration. Then who controls it? Completely under Government of India control. No provision in the Constitution with respect to their administration, completely controlled by Government of India. Completely controlled by Government of India. Fine, of course, previously Goa, Daman, Diu, Dadra Nagar Haveli, Puducherry, all of them are acquired only. Clear, but at present there is no provision. Second, whatever we wrote, it's a very simple constitutional clarity. No provision in the Constitution with respect to their administration, completely under whose control? Government of India's control. Now, this one obviously we have already mentioned. Article 1 is what? India is Union of States. We have already written it. If you want, you write it, or else it's okay because we have already mentioned it. India is a Union of States. Article 2, A. Under Article 2, you have two components. A. Parliament may admit into Union of India already existing states. This one normally students every time they'll keep having confusion. Parliament can admit into Union of India already existing states. Admit into Union of India already existing states. Fine. Example, Sikkim directly added, integrated as a state. Example, Sikkim directly integrated as a state. See, because Union of India means states and it is already an existing state. State means not state of India. Indians, not that state. State means what? A political entity as a state. Directly you take an outside territory, means a territory which is not part of India, directly make them as what? States. That's why look at it. Parliament can admit into, what is the phrase you have used? Union of India. Union of India means what you should make them as? States. So directly if you make them as state, Article 2. There is another component below. Parliament can establish states, or Parliament can establish new states which are not part of Union of India. Parliament can establish new states which are not part of Union of India. Parliament can establish new states which are not part of Union of India. New states which are not part of Union of India. In simple terms, what does that mean? For example, if an union territory you are making into state, simple example, Goa was made a state in 1987. So till then Goa was what then? Union territory. So union territory if you are making it a state. For example, or broader example you can write union territories promoted as states, or for example Goa in bracket union territory promoted as a state. So that is what? Article 2. So Article 2 includes two. One is what? Integrate into Union of India the already existing states, means directly make them a state. Second is what? Union territories you make them as states, or an acquired territory you make them as state. That is second one. Example, Himachal Pradesh made as state, Goa made as state, Mizoram made as state, Arunachal Pradesh made as state. Article 2. Clear? Now, the third question is what? Sir, what if directly, that we'll discuss. Sir, what if let's say for example Puducherry, directly as in, it was not part of India, I mean geographically, not geographically, whatever territorially, all those things, directly you made them as what? Union territory. Goa, Daman, Diu, you acquired it, added it as what? Union territory. In simple terms, if an outside territory is integrated into India as a state, that is Article 2. If an outside territory is integrated into India as a union territory, means as part of what? Not Union of India, as part of territory of India, for that you have to amend the constitution, Article 368. In prelims they can't ask all these things, but broadly just keep it in mind. Then Article 3. Parliament can make any changes in existing parts of territory of India or existing parts. Parliament can make any changes in the already existing parts. Parliament can make any changes in the already existing parts. Like what does that mean? A. Create new state or UT. Parliament can make any changes in the already existing parts. A. Create new state or UT by dividing or merging states or UTs. Create a new state or UT by dividing or merging states or UTs, existing states or UTs. Because 3 is about making any changes in the already existing parts by dividing or merging the existing states or UT. B. Increase or decrease or alter the boundaries of states or UT. Second one is increase or decrease or alter. Increase or decrease or alter boundaries of states or UT. Increase or decrease or alter boundaries of states or UTs. Boundaries of the states or UT. C. Alter the name of the state or UT. Change the name of state or UT. Change the name of state or UT. Fine. Recently Supreme Court clarified, remember Jammu Kashmir case, change the name of state or UT. After that Supreme Court recently clarified that Article 3 also includes making a state into UT, Jammu Kashmir, because it's the first time we have made a state into UT. Recently Supreme Court clarified that Article 3 also includes making a state into UT. Also includes transforming a state into UT. That's a recent kind of current affairs angle, you can say. Transforming a state into union territory. Fine. Then subheading procedure under Article 3. Not a current affairs angle, basics. Procedure under Article 3. Procedure under Article 3. A. First is what? President's prior recommendation required. President's prior recommendation required to introduce bill in Parliament. President's prior recommendation required to introduce a bill in Parliament. Prior recommendation required to introduce a bill in the Parliament. A. B. President should forward such bill to respective state legislature. President's prior permission required to introduce a bill in Parliament. B. President should forward it to respective state legislature. President should forward it to respective state legislature. Respective state legislature. C. SL, you can say state should express its opinion within prescribed time. State should express its opinion within prescribed time. State should express its opinion within prescribed time. Means that president will tell, is it 1 month, 2 months, 6 months, whatever. Then its recommendation not binding on the president or government of India or parliament, whatever. Its recommendation is not binding. Its recommendation is not binding. Then both Lok Sabha and Rajya Sabha should pass it by simple majority. Both Lok Sabha and Rajya Sabha should pass it by simple majority. Both Lok Sabha and Rajya Sabha should pass it by simple majority. Pass it by simple majority. Fine. Then next one, what you can say, that is fine. Then Article 4. Article 4. Fine, remember that's why they keep calling it as India as what? Indestructible union of destructible states, all those things you know. US is what? Indestructible union of indestructible states. Article 4. Acts passed or laws passed under Article 2 or Article 3 is only by simple majority. Acts passed under Article 2 or Article 3. Acts passed under Article 2 or Article 3 is only by simple majority. In other words, what is it not? It is not a constitutional amendment under 368. Is only by simple majority. It is not constitutional amendment under 368. Not a constitutional amendment under 368. Simple one. Then clarity, just put a subheading. Berubari Union Case 1960. Only prelims angle you write. Berubari Union Case 1960. Berubari Union Case 1960. India, Bangladesh, I mean at that time not Bangladesh, East Pakistan. Clarify that. Nehru Noon, if you want you can write that. Territorial issue between India and East Pakistan. Nehru Noon Agreement. 9th Constitution, and those 2 points you write. Territorial issue between India, East Pakistan. B is what? Nehru Noon Agreement. Nehru Noon Agreement to settle the issue. Territorial issue between India and East Pakistan. Nehru Noon Agreement to resolve the issue. Nehru Noon Agreement to resolve the issue. Then what does Supreme Court say? Supreme Court said that Indian territory cannot be ceded to another country. Supreme Court said that Indian territory cannot be ceded to another country. Cannot be ceded to another country by the executive. Cannot be given up to another country by executive. Cannot be ceded to another country by executive. So then only who can do it? It requires amendment to constitution under 368. It requires constitutional amendment under 368. It requires constitutional amendment under 368. Fine. That's why what happened? 9th constitutional amendment 1960 resolved Berubari issue. 9th constitutional amendment 1960 resolved Berubari issue. 9th amendment 1960 resolved Berubari issue. Fine. That's another clarity. If you want another one, not important, I mean important in the sense not current affairs angle, but you can write 100th amendment 2015. 100th Amendment 2015, land boundary agreement between 100th Amendment 2015, land boundary agreement between India, Bangladesh. Remember land enclave exchange. 100th Amendment 2015, land boundary agreement between India and Bangladesh. It has a historical angle. That all is not necessary. In prelims, they can't ask like that. From only prelims point, we'll discuss. Then next one, Supreme Court clarified that. Supreme Court has clarified that Government of India, that is executive, Council of Ministers, whatever. Supreme Court has clarified that Government of India can directly resolve a territorial dispute. Means if there is no legal clarity. Supreme Court has clarified that Government of India can directly resolve a territorial dispute. Government of India can directly resolve a territorial dispute. Fine, simple. Example is what? Very famous example. New Moor Island dispute between India and Bangladesh. Kachativu dispute between, which one? India, Sri Lanka. That's a kind of current affairs angle also. Not exact. Yeah, you can take it as current affairs. Not very recent. Means Lok Sabha election. New Moor Island dispute, India, Bangladesh. Kachativu dispute, India, Sri Lanka. Remember Indira Gandhi, Bandar Naike agreement, Wadge Bank, all those things. You can give a geography angle also to it. Ramnad Kings, whatever. So many angle is there. But whatever legal angle is that territorial dispute. Fine, that is the broader angles. Now, again a little more 1947 agreement, all those things is not there, not necessary. Directly you write reorganization of states. Reorganization of states. Again, very simple. 1947 Act, princely states. Three options. What are they? Princely states, three options, very simple, you know. Join India, join Pakistan, stay independent. Here, what is the issue? Who wanted to stay independent? Jammu Kashmir, Hyderabad, Junagadh. Jammu Kashmir, how was it resolved? Instrument of accession, Raja Hari Singh, Jawaharlal Nehru. Instrument of accession. Hyderabad, Operation Polo. Junagadh, Junagadh is what? Plebiscite. Cameras in, what is it? Jammu Kashmir, instrument of accession. Hyderabad, Operation Polo. Junagadh, plebiscite. By definition, it's a plebiscite one. Then, just for your clarification, because this year also they asked parts. If in case they ask again a little more factual, if they go 1950 Constitution. Fine. Part A, territories. So there were 4 territories in India in 1950 Constitution. Part A, territories. Where was it mentioned in? Part 6. What were they? Former provinces. Means in the original Constitution, there was no concept of union territories. It was mentioned as Part A territories, Part B territories, Part C, Part D. Part A territories mentioned in Part 6, which are former provinces. In other words, obviously what? Bengal, Madras, Bombay, United Provinces, all of them. Example, you know that famous Bengal, Madras province, Bombay. Then part B obviously will be where then? Part 7. So which are they? Princely states with legislature. In other words, big princely states. Princely states with legislature. It's simple, Mysore, Hyderabad, Jammu Kashmir, etc. Mysore, Hyderabad, J&K, Travancore, all of them are under part B. Part 7. Part C, part 8. Part C territories mentioned in part 8 of the Constitution, which is what? Other princely states and CCP, Chief Commissioner Provinces. Other princely states and Chief Commissioners Provinces. Other princely states and Chief Commissioners Provinces. Simple example, Ajmer, Coorg, Delhi. Other princely states and Chief Commissioners Provinces. Example, Delhi, Coorg, Ajmer. Delhi, Coorg, Ajmer. Then part D. In other words, part 9. Part D territories, part 9 of the Constitution, only, which one? ANI. Only Andaman Nicobar Islands. Only Andaman Nicobar Island. Part D territories, part 9 of the Constitution. Then here itself you clarify, 7th Constitutional Amendment 1956. Deleted, that's what is a link back you can. 7th Constitutional Amendment deleted, which one? Part 7, part 9. Deleted part 7 and part 9. Renamed part 6 as states, part 8 as what? Union territories. Part 7 deleted 7th Constitutional Amendment 1956 deleted part 7 and part 9. Renamed part 6 as what? States. Part 8 as Union territories, UTs. Part 6 renamed as states, part 8 renamed as Union territories. Fine. And then linguistic reorganization. These are all almost UPSC has forgotten, but always there is a tendency of coming back. Linguistic reorganization, language based. Fine. Just for historical angle, modern India touch if you want, first point is what? Motilal Nehru Committee supported it. If you want a modern India touch. 1928, recall the first prototype of Indian Constitution. Motilal Nehru Committee supported it. Motilal Nehru Committee supported it. Then, of course, Congress also supports, that's all not necessary. Directly, post-independence, Dar Commission, JVP Committee rejected it. Post-independence, Dar Commission, JVP. JVP, you know, Dar Commission, JVP Commission rejected it. Dar Commission, JVP Commission rejected it. Then 1953, Andhra state created. 1953, Andhra state created. And this is what Telugu areas of only which one? Madras. So Hyderabad was not there here. It was just Telugu areas of Madras province, if you have forgotten. Obviously, very simple, you know, death of whom? Potti Sriramlu, all those things you'll be knowing. If you want, you write, or else I think you'll be knowing. Then SRC, first SRC, Fazal Ali. First State Reorganization Commission, 1953, Fazal Ali. Justice Fazal Ali. First States Reorganization Commission, SRC, Justice Fazal Ali, plus whom? Yeah, correct. Plus Panikkar, plus Kunzru. Justice Fazal Ali, plus Panikkar, plus Kunzru. Fine, and what they did? accepted language reorganization, linguistic reorganization. Accepted linguistic reorganization. B. Rejected one language, one state. Rejected one language, one state. Rejected one language, one state. Then other criteria. Other criteria. So what is other criteria? A. Unity and integrity of India. Unity, integrity, security, anything can write. Unity and integrity of India. B. Financial, means financial administration. Financial and administrative factor. Unity and integrity of India. B. Financial and administrative factors. C. Cultural linguistic homogeneity. Cultural and linguistic homogeneity. Cultural and linguistic homogeneity. D. Welfare of the people of the state and country. Welfare of people of state and country. Welfare of the people of state and country. Then it recommended 16 states, 3 UTs. They did not use the name Union Territory, that used the name centrally administered, whatever concept is same. It recommended 16 states, 3 Union Territories. 16 states, 3 Union Territories. And how much did 7th Amendment create? 7th Amendment created 14 plus 6. 14 plus 6. 14 plus 6. Fine? 14 states, 6 Union Territories. 14 states, 6 Union Territories. Then came, next one is what? 1960. Bombay divided into Maharashtra, Gujarat. This one only if they ask what chronology kind of a one. Almost in the last 8-10 years there is no single question on this chronology, but you never know. When Sachidananda Sinha question can be asked, this is relatively more important. So anything they can ask. 1960, Bombay divided into Maharashtra and Gujarat. Bombay divided Gujarat into whatever, you know, Maharashtra and Gujarat. Fine, then 1961, Dadra Nagar Haveli made into UT. Recall, as I told, outside territory, if you directly make it into UT, constitutional amendment. 1961, DNH, Dadra Nagar Haveli made into UT. 10th Amendment, 1961. That's why it is amendment. Of course, it was also added in some other articles. That's a different issue. 10th Amendment, 1961. So why is it 10th Amendment? Because it is not related to Article 2. It is related to Article 368 because you are directly adding it as Union Territory. What if, hypothetically imagine, what if Dadra Nagar Haveli was directly made into state? Article 2. Understood? Now let us say, sir, today what if you make it into state? Article 2. Because today what is it? UT. Now you are, if you make it as state, Article 2. Clear? Whatever. But if Dadra Nagar Haveli and Daman Diu is merged, Article 3. Fine? Yeah, fine. So that is 1961. Then 1962. Goa, Daman Diu made into UT. That's why 12th Amendment 1962. 1962. Goa, Daman and Diu made into UT. Goa, Daman and Diu made into Union Territory. 12th Amendment 1962. Then 1962 again. Puducherry made into UT. Same. 14th Amendment 1962. Fourteenth Amendment 1962. Fourteenth Amendment 1962, Puducherry. Then 1963, Nagaland out of Assam. 1963, Nagaland out of Assam. Factual parts. 1963, Nagaland out of Assam. 1966, Punjab divided into Punjab, Haryana, Chandigarh. Punjab divided into Punjab, Haryana, Chandigarh. Master Tana Singh, all those things. Punjab, Haryana, Chandigarh. 1966. 1971, Himachal Pradesh made into state. Means Article 2. Himachal Pradesh made into state. 1971. HP made into state. 1972. 1972. Meghalaya, Manipur, Tripura made into states. Meghalaya, Tripura, Manipur made into states. Arunachal Pradesh, Mizoram, UTs. Meghalaya, Manipur, Tripura made into states. Arunachal Pradesh and Mizoram made into union territories. Fine, then Sikkim. You don't have to understand overall things, everything. Core point you write. 35th Amendment 1974. 35th Amendment 1974. Sikkim made into associate state from protectorate state. 35th Amendment 1974. Sikkim made into associate state from protectorate state. It's a special category given to them. Asymmetric again. Made into associate state from protectorate state. Article 2 capital A and 10th schedule added. Article 2 capital A and 10th schedule added. So remember, today 10th schedule is what? Today 10th schedule is what? Anti-defection law. But you are talking about which year? 74. When did anti-defection law come into force? 85. So 2A, 10th schedule added. Then 36th Amendment, okay, below that you can say plebiscite conducted, Sikkim integrated. Plebiscite conducted, Sikkim integrated. Fine. 36th Amendment 1975. Article 2A, 10th schedule deleted. 36th Amendment 1975. Whatever you had added, both of them you have to delete. 2A and which one? 10th schedule deleted. So you don't have it in the constitution as of now. Article 2 capital A and 10th schedule deleted. And what they added? 371 capital F added. 2A and 10th schedule deleted. 371 capital F added. 371 capital F added. Fine, that is 36th Amendment 1975. Then 1987 directly. Goa, Arunachal Pradesh, Mizoram states. 1987. Goa, Arunachal Pradesh, Mizoram states. Goa, Arunachal Pradesh, Mizoram made into states. Then 2000. Chhattisgarh, Jharkhand, Uttarakhand, Uttaranchal, whatever. 2000. Chhattisgarh, Jharkhand, Uttarakhand. Chhattisgarh, Jharkhand, Uttarakhand. Then 2014, you know, Telangana. 2019, J&K and Ladakh as UTs. 2019, Jammu Kashmir and Ladakh as UT. Jammu Kashmir and Ladakh as union territories. Then 2020, DD-DNH merged. 2020, DD-DNH merged. 2020, DD-DNH merged. DD and DNH merged. Fine. Yeah, so this is overall about part 1, union and its territories. After this, actually, we have to go to which one? Preamble. Before that, let's look at few PYQs. Mostly we have tried to, after preamble, we'll understand it better, but Okay, so go through it. If in case you can recall, tell, because it's related to preamble and so many other things, but I think by now you would have obviously gone through it. Economic justice provided in C. None of the above. Huh? C. Fundamental rights and DPSP. Fine. Anyhow, preamble is not done, but simple, obviously, but justice. Correct. Remember in preamble, liberty of freedom, liberty of correct thought, expression, faith, belief, worship, justice, political, social, and of course, entire DPSP is about the idea of welfare state and justice. This is done. Not a feature of federalism. Indian federalism. D for Delhi. Okay, fine, correct. Then broader point you can easily write, attempt, or anyhow we'll do it again in your preamble chapter. Equality in society means absence of privileges. Fine. Even if you know Article 14, equality before law, first provision is what? Absence of privileges. It is simple point related to or question related to Article 14, equality before law, or rule of law under that equality before law. Absence of privileges. This is more simple. The mind of the makers of constitution is reflected in preamble. Which case? Which case? Case I am telling. Yelli. Berubari Union case. So that anyhow we'll write tomorrow in the preamble chapter, but very, very famous statements. This we keep on telling. Multiple times I would have told in polity, democracy is based on the principle of popular sovereignty. Popular sovereignty means what? People are the ultimate decision makers. Use that logic and tell me the answer. Popular sovereignty, people are ultimate decision makers. Okay, fine. I thought there's some other option. Yeah, why not? Like, let's say C. Or why not? Okay, fine, bad. This one, because the extraordinary men and superior individual, all those things. Always democracy means what? Common man. That's why popular sovereignty. People are common man is the ultimate decision maker. Yeah, just now I told you. Liberty of liberty of thought, expression, faith, belief, worship. Look at it. Thought, expression, faith, belief, worship. So which is not there? Economic liberty not there. This I would have done in basics. If you can recall, please look at it. So wordings here, this you might have seen. But this year UPSC, I don't think they use this logic, but this is the key. Nicest appropriate relationship. B. If there are no laws, there is no liberty. If you can recall your basics also would have done, or else again we'll write that tomorrow. In other words, if there are no laws, replace the word law by what? Reasonable restrictions. If there are no reasonable restrictions, liberty will be easily misused. Remember, we keep using that. Liberty is not absolute. Fundamental rights are not absolute. They are all what? Qualified. Qualified means what? Reasonable restrictions. Fine. Again, look at the wordings. That is the word. Most appropriate definition of liberty. Most appropriate is the key, and then look at it. Again, tomorrow we'll do it in detail. But if you can recall from your basics. Opportunity to develop oneself fully. Because if you can recall, this is also a definition. But this is, can you recall? Negative liberty. Freedom from, freedom to. If you don't recall, don't worry, we'll do it tomorrow. Simple context. If the same question says in the context of polity, which of the following is simplest definition of liberty? Answer is what? Simplest definition. But what is the wording here? Most appropriate definition. So simplest, this one, absence of restriction. Most appropriate, negative, positive. Freedom from, freedom to. That we'll discuss tomorrow. This one also, if you can recall, broadly tell. Don't tell me from what the PYQs, this, that, here and there you would have attempted. You should tell me the reason. Samadhanam, nodಬೇಕು options. Part of the constitution but has no legal effect. Not a part of constitution but has no legal effect either. D, A, D. Okay, D, tell me the reason then. Sir, polity all ಮಾಡ್ದಂಗಿದೆ sir ಅದಕ್ಕೆ. Correct. So, okay, give me an example. Little more specific. Okay. Yeah, preamble means which value? Correct. Simple example, what they are trying to say is, if you can recall, again tomorrow we'll do it. Preamble is, according to Supreme Court's clarification, non-justiciable in nature. Means what? State has no obligation to implement it. So hence it has no legal effect. So that's why statement A is actually correct. Look at the statement A, what does it say? It is a part of constitution. Yes, Keshwananda Bharati case has told it is a part of constitution but has no legal effect. See, they could have used the term non-justiciable but they are not using it because they know obviously you have violated Lakshmikant. So that's why no legal effect. In other words, non-justiciable. Yes, it is non-justiciable, correct. But what does statement 2 say? Not statement 2. Statement 4 says, yes, it is a part of constitution, correct. This part correct, which is what? Keshwananda Bharati case. No legal effect, correct. In other words, it is non-justiciable. Then more clarity, independently of other parts. Means if other parts of the constitution are not implemented, you can't implement preamble. Or reverse it. If you implement other parts of constitution, you can implement preamble. Means if fundamental rights are followed properly, liberty is upheld. If DPSPs are followed properly, justice is upheld. If fundamental duties are implemented properly, fraternity value is implemented. So, yes, preamble by definition you can't implement it, but how can you implement it? By implementing other parts of the constitution. Or in other words, if other parts of constitution are not implemented, preamble also has no legal effect. That's the idea. So actually statement 1 and 4 are more or less the same. What have they added? This part they have exactly added it. Now, so this is a trick that UPSC normally plays. Look at it even here. They could have easily asked simplest definition. In fact, they have asked, they should have put it here itself, because 3 years, 17, 18, 19, continuously 3 years question on liberty. This is 19 question. This is 18. 17 was 17, this one, and another question, which is the most simplest definition of liberty. And simplest definition means, as I already told, absence of restriction. Same way here what they do, very easy option they'll give it as A, but the real answer they'll put it in D. Very easy option they'll put it in A or B, but the real option they'll put it in D. That's a very simple trick that UPSC plays. This year they have not tried to play it, but anytime that trick can come back, because they know that you'll be waiting to tick it. So they'll use it as a bait. Easy option they'll put it as A, but if you don't look at fourth option, the answer is gone. So that's a very simple skill. Unless you go to the last option's last word, please don't finalize your answer. Don't be in a rush. Understood? Because easily, that's a skill part. They can easily put a trap. Then where are the schedules one? Because schedules. This is very simple. Obviously, I don't have to tell. Fifth and sixth schedule. Whose products? Yeah, fine. D, none. Okay. Only one. Oh, that means there is a little confusion. Go back to 9th schedule where you have mentioned it. There itself I could have given a little more clarity also, but I thought I will mention it in 31B, because anyhow we are discussing it, we will mention there itself. Go back to article, 9th schedule, 31 capital B. So first fact added by which amendment? Which amendment? First amendment 1951. And then you have mentioned it. Those acts of parliament or state legislature which are exempted from judicial review. There you clarify. Please write the statement 1. Only parliament has the power to add an act to 9th schedule. So it can be a state legislature's act, but who can add it to 9th schedule? Only parliament. Only parliament can add an act to 9th schedule. So in other words, even if state legislature has passed an act, if they want to add it to 9th schedule, they can't add it. Who has to add it? Parliament has to add it. Only parliament can add an act to 9th schedule. How? Amendment of Constitution 368. Means special majority. Only parliament can add an act to the 9th schedule. How? Amending the constitution under article 368, special majority. Fine. Then again, if you want, here itself you write the case. IR Koholo case 2007. IR Koholo was the state of Tamil Nadu. IR Koholo case 2007. Even if an act is added to 9th schedule, it can be questioned by the judiciary. IR Koholo case 2007. Even if an act is added to 9th schedule, even if an act is added to 9th schedule, it can be questioned by judiciary. Means judicial review will apply. It can be questioned by judiciary. If it violates basic structure, what you can do? unconstitutional. It can be questioned by judiciary. If it violates basic structure, declared unconstitutional. If it violates basic structure, can be declared unconstitutional. But which one? Only those acts added after 24th April 1973 can be questioned. But only those acts added after 1973, 24th April, means which one? Yeah, because the progressive application, before that the concept of basic structure itself is not there. How will you apply the act or doctrine? But only those acts added after 24th April 1973 can be questioned. Fine, now you look at it and tell me. Yeah, see? Yeah, okay, fine. Yeah, this one. Look at the key, they are talking about whose land? Tribal land. Whenever you get tribes, which schedules? 5th and 6th, both are there. That's why they avoided giving both. They have given only 5th. Obviously, answer is First Amendment 1951. Again, look at it. Kind of few favorite areas. See, imagine, I think this is the third time we are looking at 5th schedule. Same question only. Whatever you have given here, transfer of tribal land to private parties for mining, same concept. Yeah, same question it is, nothing is changing. Yeah, the recent one. Even if you have simple logic that Bodo, Maithili, Santali, Dongri was added together, you take out Maithili, answer is there. Please, if you have forgotten, please go back and look at your 8th schedule. Just now we wrote this. It's a factual part, yeah, you may have that problem to remember easily. But look at the amendment, look at the languages. Correct? What is the answer? ಎಲ್ಲಿ ಇನ್ನೂ ಯಾವ್ದು ಬೋಡೋ ಮೈತ್ರಿ ಸಂತಲಿ ಅಂತಿದ್ದೀರಾ ಈ clearly you have mentioned 71st amendment 1992 which languages? Yes, Konkani, Manipuri, correct, Nepali. So Maithili was added by which amendment? 92nd amendment 2003. Again, go back to parts if you have confusion, again because it's a factual topic. Parts, entire parts you have mentioned, please go there. A, okay? You said A. D. Any other things? Okay, some people are having a doubt on, sir, the provision, first statement says powers of the municipalities are given in part 9. If you go to a little more detail, actually in part 9, powers are not detailedly mentioned. It is in general about municipalities. Powers of the municipalities will be given by the state legislature. So if you go a little in depth, answer will become actually 2 and 3. But probably we still don't know because key is not out, because we still have to wait. 80-90% answer will be all, means all of the above, D. I mean, got an idea, right? Why I am saying maybe it can be 2 and 3. What is the reason? Powers of the municipalities, remember in the constitution they clearly tell State legislature will determine the powers of municipalities. So when they say powers of the municipalities are given in, does the word given means mentioned? If you interpret it as mentioned, answer is what? Wrong. Because there is no clarity in the constitution. It is not mentioned in constitution. Who will give it? State legislature will give it. If the UPSC interpreted as given means given, it is just told there, then it is correct. So we still don't know. Remember, even in basics also I keep telling polity, judicial review is provided by the constitution. How do you interpret the term provided? If you take it as mentioned, statement is wrong, because judicial review is not mentioned in constitution. If you take it as supported, judicial review is supported by constitution, answer is what? Correct. So what is the meaning of the term provided? There was a confusion. Same way, probably, what is the meaning of the term given? We have to wait. Mostly it is all of the only. If in case they took another interpretation, it will become what? B. If they take it as given as what? Mentioned. That we have to wait, but don't worry, that we'll take off it later. Okay, I think probably that is the schedules and preamble. Anyhow, we'll do it tomorrow. And the basics of parliament, I think, I don't know where they have put parliamentary system. Maybe I think they would have put it in parliament chapter. Okay, we'll do it later. This file and the first file, I'll make them upload in your group. And mostly same timings will continue, because I'll be having optional classes also in the morning. Fine. Okay, we'll meet tomorrow then.